All right, here we go. Chapter 3. So, in Chapter 2, we took a look at the Constitution, how it came to be, what its structure is, how that structure different from the Articles of Confederation. One of the things that we mentioned and we talked just a little about was this idea of federalism. So, the Constitution created a federal type of government. And to say what that is difficult, as far as take a, from the perspective we've looked at the Constitution, we've examined the Constitution, and the chapter headings in a sense would suggest we're done with that. There's chapter 1 was Constitution, or excuse me, chapter 2 the Constitution, chapter 3 federalism. The reality is, when we're looking at federalism, we're still looking at what the Constitution is and what it means. So think of chapter 3 as still dealing fundamentally with the Constitution of the United States itself. So, what exactly is federalism? Again, we hinted at it last week, but your text defines it as the constitutional arrangement by which two or more levels of government share formal authority over the same area and people. So you've got the two levels of government in the United States being the national, or as it is usually called, the federal government, and then you have the regional, or as they are usually called, the state governments. So it's more accurate to refer as the central government as the national government, but the reality is most people don't. They call it the federal government. But in reality, the type of government we have is a federal government where you have these two or more levels of government that are sharing authority over the same people and the same area. So the best example of this is, of course, the United States. It's the country that created this type of federal, that created a type of federal government. And there are others, but there are relatively few nations in the world that have federal type of government, some in Central and South America. But for the most part, most nations don't. So it is interesting how that, and it really came about because of our history. That you have these 13 independent colonies, which were really states under the Articles of Confederation, and that's how this federalism system of government really developed. The founders didn't have to choose a federal system of government. They could have gone with what they were used to in Great Britain, which was the unitary system, or they could have stuck with what they did in the Articles of Confederation, which was the Confederate system, or a confederation. So a unitary government or a unitary system is a government in which supreme power resides in the central government. You do have local governments, but they really are an administrative unit of that central government. The central government can abolish them at any time they want. So in the 1980s, when Margaret Thatcher was Prime Minister of Great Britain, this is the time when Ronald Reagan is President of the United States, she one time came into what would be the equivalent, if they had a federal system, of the London City Hall. And there were signs in there which were critical of her, and she said to one of her aides, go to the London City Hall and close them down. They no longer exist. That's an example of a unitary system of government where all power resides in the central government. Now, if President Biden came, or any president came to any city or state, and there was things said about him that were critical, or posters, and he wanted to shut them down because that it just couldn't happen, because they have real and independent power in a federal system. They are their own entity. Two levels of government, each with real and independent power. The United Nations is also a unitary system. That's it. That's all there is. There's one government. It's the United Nations, and of course they're trying to control these other governments, but they really have no power over them. In addition, another type of system the founders could have chosen was a confederation. A confederation, and think of the original 13 states or colonies as we go over this, is a loose coalition of independent states who band together for limited purposes, defense or trade. The Confederate government is weak and subordinate to these what would be we would call the central government, um, and so the larger the central government, the overarching government, is weak to its independent parts. Um, it is really subservient to them, and so again, the 13 states, when they confederated and became the first nation in the United States, they were a confederate form of government. The U.S. Constitution and federalism. Now, this is what's going on with the U.S. Constitution and federalism. So, some provisions delineate the scope of national government and its powers, others restrict it, and the remaining shape the relationship among the states. That's what's going on. So, you think about the Constitution and what it does. Some of those powers detail the scope of the national powers, some restrict it, and some detail the relationship that the states have among each other. So let's look at the scope of national powers first. So there are certain enumerated powers that are found in Article 1, Section 8 of the Constitution. That what they were really trying to do was not repeat the mistakes that had occurred under the Articles of Confederation. Now, when we say enumerated, we mean listed or numbered, spelled out, so to speak. We're not guessing as what those powers are. They are listed, they are numbered. So the powers that the founders gave in the Constitution, and these are major powers. They were lacking in the Articles of Confederation. So they gave them the power to tax. Big deal. Remember, they didn't have that before. They could only request that the state send them money. They gave them the power to borrow money, to regulate interstate and foreign commerce. Again, major powers lacking in the Articles of Confederation. They weren't going to create a system of their own making that didn't have those powers. Also, to provide for the common defense, to raise and support an army and declare war. Defining naturalization or citizenship. Then, to make sure that there was a power, that there wasn't a power that the government needed, that they hadn't thought of, but without trying to create an all-powerful government, they put in what would become known as the necessary and proper clause. The necessary proper clause. Sometimes people refer to this clause as the elastic clause because it has enabled Congress to stretch its powers. Because Congress has the right to make all laws which shall be necessary and proper to carrying out its constitutional responsibilities or the foregoing powers. The Commerce Clause. The Commerce Clause. Again, repeat that here because it's such a big deal. So what does the Commerce Clause say? It granted to Congress the power to regulate commerce with foreign nations and among the states. So Article 6 was the Supremacy Clause, just to make sure that states didn't say that they were supreme over the national government or the federal government. The Constitution, it says the Constitution and federal laws are the supreme law of the land. And the Constitution went on to say anything in the state constitution or laws to the contrary notwithstanding. In other words, they were saying, states, you can say whatever you want. We are the supreme law of the land. So right now in the United States, there's this marijuana issue going on. So some states have legalized it, but it is still against the law as far as the federal government is concerned. This then would be a conflict, and ultimately federal law reigns supreme. If the federal government wanted to come in, they could come in and bust people for it. There you have it. All right, Constitution, U.S. federalism, powers, restrictions of powers. So we're talking about the scope of government. Certain powers were given, certain powers restricted. Uh, so the central government, the powers of the state governments were never listed in the original Constitution. So states are going to argue that they have certain powers, and they may, because the state powers were never listed in the original Constitution. There was consensus among the framers was that states would retain any powers not prohibited by the Constitution or delegated to the national government. So they would kind of have those powers that they always had, as long as it wasn't prohibited or they weren't delegated. Those powers weren't delegated. Now, during ratification, so we create the Constitution, but then it's got to be ratified or approved by the states. The anti-federalists, those who felt that the Constitutional Convention had created a government that was too powerful, they insisted that a Bill of Rights be added to affirm certain reserved powers. So, for instance, there was nothing said in the Constitution of the right to free speech, the right to keep and bear arms, the right, criminal rights. And so the anti-federalists wanted some of these rights. And so, as part of the Bill of Rights that would be adopted, they got in the Constitution through the Bill of Rights, it says the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So that was in the Bill of Rights, Amendment 10. Congress, in Article 1, again, restrictions on the central government's power. Congress cannot suspend the writ of habeas corpus or bills of attainder or pass ex post facto laws. So a writ of habeas corpus basically allows a judge to demand the government bring a individual who's in jail before him or her and state why that individual is in jail. This is a major protection against the government just locking people up and throwing away the key. That is in there, in the document itself, not even in the Bill of Rights. They knew they needed that. Bills of attainder. Bills of attainder allow a government to convict a group of people just by legislation. And in the Constitution, we didn't want that. So we said no bills of attainders, no ex post facto laws, no laws passed after the fact and then applied retroactively. The government cannot do that. So some restrictions on state power. Okay. State governments, they also had some restrictions against them. They could not enter into treaties, they could not coin money, and they could not levy taxes on imports or exports. Those are some restrictions of state governments. And amendments prohibit states from denying citizenship rights that individuals are entitled to as U.S. citizens. So if you have a right as a U.S. citizen, the states cannot deny you that right. All right. So we've already gone over all these, but I want to just bring this 10th Amendment up relative to what we've gone over. So the Bill of Rights was passed in the first Congress. That's the anti-federalists got the agreement from the Federalists that if the Constitution went into effect, that at the first Congress they would pass a Bill of Rights. And the 10th Amendment affirms these states' reserved powers. It says the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So there it is in plain English and plain writing, just to make sure that does not get infringed upon. All right, there are concurrent powers. Concurrent powers are powers shared by both levels of government. Power to tax, power to lay and collect, the power of the police power to protect us. Lots of concurrent powers both levels of government have. All right, the relationship among the states. The relationship among the states. In other words, states in this new government are going to owe each other certain duties. And And this is found in Article 4, Section 1 of the Constitution. It's known as the full faith and credit clause. What it requires is that the states accept court decisions and public acts, contracts from other states. Marriage, for example. So if I get married in California and I move to Nevada, I am still married even though I was married in California. This is what they mean by full faith and credit clause. This, of course, in the world in which we now live, where rights are being expanded, this has this raised a number of concerns when homosexual marriage was first being legalized in the United States. So Hawaii passed a law which allowed gays to marry. And other states were concerned that when this happened, based on the full faith and credit clause, they would be required to accept these marriages as legit. So Congress passed, and President Clinton, this is interesting, President Clinton, he signed into law what became known as DOMA, or the Defense of Marriage Act, which basically said that gay marriage didn't count with respect to the full faith and credit clause. And you can get into an argument here saying, wait a second, if there's a full faith and credit clause, Congress can't just make a law which restricts that, because the full faith and credit clause is in the Constitution, is higher. Constitutional law is higher than legislative law. But nevertheless, that's what they did. But eventually what would happen, the Supreme Court in the Hodges case, Obergefell versus Hodges, basically said that based on the 14th Amendment, that Congress or any state couldn't forbid gays from marrying. So that's what happened there. There's also the Privileges and Immunities Clause, and it prevents states from discriminating against non-residents. So when I drive from California across the nation or whatever, I don't have a license in those other states. If I get pulled over, am I given a ticket for driving without a license? No. I do have a license. I have a driver's license, and they have to accept that. Tuition doesn't mean there can't be differences. So there's, many of you may know, there's maybe some of you are even paying it. There's out-of-state tuition for colleges. Can you argue that that is a violation of the Privileges and Immunities Clause that prevents states from discriminating against non-residents? Well, you can argue that, but the courts haven't ruled it that way. Hunting licenses for out-of-state. Hunters are more expensive than for in-state hunters. The Supreme Court has ruled that's all okay. The thinking is these individuals who are getting hunting licenses from one state that live in the state, their taxes have been supporting all sorts of things within the state, and therefore they shouldn't have to pay the higher fee. And that's the thinking. All right, so if you look at the Constitution, it's much more specific about the powers the states don't have than those that they do have. So here are some powers that are reserved to state governments. Here are powers that are denied to state governments. There's never any list of powers really that states have. Yeah, there's a list of concurrent powers that both the central or the federal government and the state government share, but it doesn't say, okay, states, here are the powers that you do have. So it's just not specific about that. Get rid of that. One sec. There we go. All right. Which is interesting. But if you go back to the 10th Amendment, that makes sense because of what it says. Powers not delegated in the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. So that it would make sense that all that would be in play. All that would be in play. There'd be too much to list. All right. Now, how American federalism was viewed after the Constitutional Convention has not been the same way that it's played out over the years, which again makes sense. It's going to develop. It's going to change based on the experiences that the nation goes through, etc. But what the Constitution tried to do was try to sketch out a framework that aimed to balance the forces of decentralization, meaning decentralization where the states just dominated everything, versus centralized government, where Washington, D.C. Governs everything. So they're trying to balance those forces. And this is what the Constitution is attempting to do, create some room to maneuver. This allows officials room to maneuver and has led to changes over time in what federalism means. So now we want to look at some of those changes in time over what federalism means. Okay, so again, I repeat that right here. Here's the next statement. Professor Woodrow Wilson, now you should recognize the name rather. Woodrow Wilson was president of the United States during World War I. Before he was president, he was a professor at Princeton, a government professor. And this is what he said, speaking of federalism. He says, the relationship between the national and state governments is the cardinal question of our constitutional system, a question that cannot be settled by one generation because it is a question of growth, political and economic development, which gives it a new aspect and makes it a new question. So again, he's saying, look, this is what is happening. There's this balance, this tug of war between the federal and state governments, and the Constitution has sketched out this framework which allows room to maneuver so one doesn't become too powerful over the other, or if it does, the other one can push back. So remember what Wilson said there, and that'll help you understand what's going on. So we have the founding, and with the founding, there's this struggle between national and state powers. States didn't want to just walk away and say, gee, oh, wow, we created this national government and this federal government. Now we don't have any power in the national government. The federal government has all this power. They didn't do that. So what the founders were trying to do was to create a system whereby personal liberty would be protected. Remember, life, liberty, and property was one of the things that they were trying to protect. So federalism is kind of, it's not unlike separation of powers, but it is a very unique kind of separation of powers, creating two levels of government, and so unique that it's really classified under its own term, and that is federalism. In other words, both of these levels of government can kind of push back, kind of a check and balance on the other. Now, there were some accidents of history that we talked a little bit about last time that really caused this new type of government to be created. And those accidents of history were suffered by the same men, the same individuals, the same society. And what we have here with what happened with George III in England, granting too much power to any one person concentrates power and risks tyranny. George III, granting too little power risks tyranny of the mob, as under the Articles of Confederation. So remember, when they were creating the Constitution, they were mindful of both of these problems. And so they tried to create a system that would deal with both of those issues. When the Constitutional Convention was over, there were really two views that people took and people walked out of that Constitutional Convention with. Now, Thomas Jefferson was not at the Constitutional Convention. He was in Europe doing some diplomatic work. But he had his views. So his view and the people, he became kind of the leader of this view, hence the name, the Jeffersonian view, It is also the state supremacy view or the strict constructionist view. So he believed the Constitution created a limited government, and he had some proof for that. He believed the founders themselves were creating they thought they were creating a limited government, and as proof of that, you've got the 10th Amendment to ensure that what was created and in Philadelphia was a government of limited powers. So powers not granted to the federal government are reserved to the states. Says so in the 10th Amendment. As a group, the founders at the outset assumed that the federal government would only have those powers that were given to it in the Constitution. It was to be a government of limited powers. It just couldn't do whatever it wanted. Furthermore, the Constitution itself was a product of the states. The states came together at the Constitutional Convention. It was state delegations that came. They created the government. And so the Jeffersonian view believes that the federal government is a product of the states, and therefore the states are superior, as it were, to the federal government. So the principal threat to people's liberty was likely to come from the national government. This is what Jeffersonians believe. Hence, the federal power should be narrowly construed or strictly interpreted. That's what Jeffersonian thought. Now, in contradistinction to that, in opposition to that, was the Hamiltonian view. Hamilton was at the Constitutional Convention, and he was for federal supremacy. He believed that the federal government was supreme, and it was created that way over the states. His view is also known as the broad construction view. And he's got some proof that he can point to that says he's right. So the framers knew that they could not foresee all future problems, and so they wanted to create a government that had authority to govern, and so they added provisions to the Constitution to make sure that that would happen. So Congress shall have the power to make all laws which shall be necessary and proper to carry into the execution of the foregoing powers. So you've got the elastic clause or the necessary and proper clause, and it allowed Congress to stretch its powers. They didn't want to get stuck in a situation like they were in the Articles of Confederation, where they couldn't act because there was no power given in the document for them to be able to do certain things. So just to make sure of that, they create the necessary and proper clause in the Constitution. There's also the supremacy clause, which says that the Constitution, its laws, federal laws, are the supreme law of the land, anything in the state constitutions to the contrary notwithstanding. So you've got the supremacy clause that says federal supremacy is what this document is creating. And you've got the historical context. Given the economic conditions that caused people to form a new government, why are we now going to construe that they don't have the power that we wanted them to have when the Constitution is created? Otherwise, it's going to be no better than the Articles of Confederation. And clearly, that was not the intent of the framers or the founders at the Constitutional Convention when they created it. So who's correct? Is it the Hamiltonian view or is it the Jeffersonian view? You've got this balancing act, right? Now, particularly when we go back, what are the framers trying to do? They're trying to balance the forces of centralization and decentralization. So who's correct? Well, and again, going back to Wilson, it is a question that each generation has to answer what federalism means. And so let's go back and do a little history and see how they originally answered that question. And so the Supreme Court weighed in on the question. And this is the McCulloch versus Maryland, 1819, is the second most important Supreme Court case ever decided if you look at it, if you want to rank them. The first is Marbury versus Madison, which we'll get to. But the facts of the case were there was let me back up. Congress had passed a law creating a national bank. And states and the Jeffersonians, the strict constructionists, said, no, you don't have that power, because no power in the Constitution was given to create a national bank. So states didn't like this, and so they began to tax the national bank. So James McCulloch, a cashier of the Baltimore branch of the Bank of the United States, when they came in and tried to collect this tax, he refused to pay the tax on the Bank of the United States in Maryland. He was tried and convicted in the state court for failing to pay the tax. So subsequently, he appealed to the Supreme Court, and the court had to answer two questions. And here are the two questions, and they answered them unanimously. The questions were, could Congress set up a bank since no power to establish a bank was expressly given in the Constitution? So remember, we're supposed to be a government of enumerated powers or limited powers, and none is given. So this is a good question. And could a federal bank be lawfully taxed by the state? Assuming that they can it be lawfully taxed by the state? So this is what the Supreme Court is got to look at. So, so here's the first question, and the answer this court said is yes, that Congress can establish a bank even though none is given. So listen to the reasoning as I read through this. The federal government possessed only, so this is Marshall. Marshall is the Chief Justice of the Supreme Court. The federal government possessed only those powers enumerated in the Constitution, but the meaning of those powers required interpretation. Marshall argued, though the specific power to charter a bank is not found in the Constitution, there is, however, the power to lay and collect taxes, issue currency, borrow funds. To carry out those powers, Congress may reasonably decide that chartering a national bank is necessary and proper. Okay, so you see, he's using the necessary and proper clause to say Congress has a right to create a bank. And he makes a powerful argument. They do have the power to lay and collect taxes. What are they supposed to do with these taxes once they get them? Are they supposed to take them to the White House, put them under the president's mattress? No, Marshall's saying. They can create a bank. They can create a bank to put them there. So because of this, these powers, when you take one power and deduce from it or imply another power from it, this is what would become known to be called as implied power. So it's an implied power that Congress has the power to create a bank because of the specific powers in the Constitution imply it. Now, of course, the problem with that is you get into interpretation about what is implied and what is not. Okay. Again, going on with this same argument, this is Marshall continuing. He interpreted the necessary and proper clause to give the phrase an expansive reading. He says, let the end be legitimate. Let it be within the scope of the Constitution. What he means by that is there's powers that you can trace these implied powers to. So let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but are consistent with the letter and the spirit of the Constitution, are constitutional. Jefferson, on the other hand, would argue for an interpretation of the necessary and proper clause is absolutely essential. Absolutely essential. That's the only time they can use that. And the Supreme Court disagreed. So that's where you get these implied powers from. Okay, could a federal bank be lawfully taxed by a state? And Marshall answered that no. He answered that no. The reason he answered that no is, again, he looked at the historical context. So he's arguing that yes, the states did send delegates to the Constitutional Convention, but to make sure that it was approved, that it was a people's document, it was the people who had to vote for it in the states as to whether or not we're going to be ratifying this Constitution. So this is the people who created the Constitution, not the states, is his argument. And so, since the people are the sovereign, the federal government is supreme in its sphere. The people created it, they gave national supremacy to the states. And so, the only way for the federal government to be supreme was for the powers to be immune from state destruction. And since the power to tax involves the power to destroy, these were Marshall's words. The power to tax involves the power to destroy. The Maryland law was unconstitutional. So the legacy of Marshall versus McCulloch versus Maryland is that national law is supreme over state law. Big deal, big deal. This is why it is the second most important Supreme Court case ever. National law supreme over state law. Little cartoon here. 1819, establishing a national bank was necessary to carry out the Congress's power to tax. So this is supposed to be Marshall here and Maryland. Exactly. That's why we wanted stopped. They wanted that power. They wanted that power. The powers, centralization, decentralization. All right. Another landmark case was a case called Gibbons versus Ogden, just 5 years later. And it goes to some of those same issues. So what is, in this case, not what powers does Congress have, but what is exactly interstate commerce? So in the Constitution, we gave Congress the power to pass interstate, or power to regulate interstate commerce. So interstate commerce, there's two ways to look at commerce. You can look at it as from interstate commerce or intra. So interstate commerce is between, and intra is within. And the states, some of the states, or the Jeffersonians, were making this distinction. There's interstate commerce, which is between. There's intra, which is within. So their argument was that the national government couldn't legislate things that were within the states. And the Supreme Court says, no, not so. Again, this is Marshall. He says commerce is a stream. So he's using this analogy. Commerce is a stream, and anything that affects that stream can be legislated by Commerce under the Interstate Commerce Clause. So the Interstate Commerce Clause creates this expansive view of interstate commerce. And today, this Interstate Commerce Clause, the power to legislate based on the Interstate Commerce Clause, is one of the most important sources of congressional power. Remains so today. Now, the ultimate showdown, historically speaking, for what federalism meant was the South. So we've got this debate between the Jeffersonians and the Hamiltonians, which continues after both of them die. But historically speaking, the ultimate showdown comes into the Civil War. So you still had states saying no, states are supreme. National government saying no, national government is supreme. Showdown, the Civil War kind of puts an end to all that. So the defeat of the South had two major impacts on really what we view as the interpretation of federalism and the powers of the national government as opposed to those of the states. The Union victory put an end to this right of states to secede and to challenge legitimate national laws. So, in other words, the South is saying, yes, we know you're, the states are saying, yes, we know you're supreme. Congress imposed several conditions for readmitting former Confederate states into the Union. Among them was the ratification of the 14th and 15th Amendments. In some, after the Civil War, the power balance shifted towards the national government. So we went from more of the decentralization prior to the Civil War or after the Civil War. Now we're going to more centralization, which is occurring. In other words, more power is being found at the national government level. Now, you could look at this idea. So let's go back to this slide. We've just said that, is that the one I wanted? We've just said right here. We just said that one of Congress's most important powers is this power of interstate commerce. All right. Now, does that mean that that power is absolute? So there was a case in 1994 uh, where Congress passed, um, based on its interstate commerce, an act that prohibited violence against women in 1994. Um, and there was federal civil remedies for victims of gender-motivated violence and gender-motivated crimes of violence. Um, and the court said, no, the power of commerce to regulate interstate commerce does not give Congress the authority to do that. In other words, this is a state function, is what the court is saying. So just because Congress has this interstate commerce power does not mean they can do whatever they want whenever they want. We are still a federal system. We are not a unitary system. So that is 1994. In 1995, you get the same kind of thing going on. In United States versus Lopez, Congress passed the Federal Gun-Free Zone Schools Act of 1990, and it forbade a possession of a firearm within 1,000 feet of a school or a park. And by a 5-4 majority, the court said the act had nothing to do with commerce. Nothing to do with commerce. Okay, so even though Congress has that power of interstate commerce, it does not mean it's absolute. So after the Civil War, the South admits that the national government is supreme. But they're basically saying that there's a proper relationship between the national and state governments. So these what will become what will become known as dual federalism. So in dual federalism, this is what is believed. So in this ongoing evolution of what federalism is today, this becomes known as dual federalism. So after the Civil War, South says yes, federal government is supreme, but they're supreme only in the sphere the Constitution is delegated to it. So these are the components of what people thought dual federalism meant. The national government rules by enumerated powers only. So in other words, there's still this idea it's got to be tied to the Constitution, what the federal government is doing. And as proof of that, you've got these two cases back here where the federal government just can't do whatever it wants. Second, the national government has a limited set of constitutional purposes. Again, it can't do just whatever it wants. And each government unit is sovereign within its own sphere. And finally, the relationship between the nation and the state is best characterized by tension rather than cooperation. So this is what, after the Civil War, this is kind of the view of what was going on with the meaning of federalism. And this becomes known as dual federalism. All right. Now, eventually things would change. Again, going back to Wilson's statement that economic circumstances, life in general, is just going to make what federalism means different. And so what changed was the Great Depression. The Great Depression caused people to lose their jobs. 25% of the people were out of work. There was real hardship in the United States. And so because of that, we get an emergence of a new type of federalism that becomes known as cooperative federalism, where the federal government is coming in and helping out in ways that it would have been deemed unacceptable for them before, that they would have exceeded their constitutional duties. Okay. Now, so what are the elements of this cooperative federalism? One, the nation and national and state agencies typically undertake government functions jointly rather than exclusively. That is the function. So when somebody gets welfare, usually what is done, the money is provided by the national governments, the state agencies distribute it, and to have some rules of their own with respect to it. Two, the national and state governments are routinely share power and coordinate their actions to solve national problems. So you can see why cooperative federalism. And three, power is not concentrated at any government level or agency. The fragmentation of responsibilities gives people and groups access to many venues of influence. All right. So these are the hallmarks of cooperative federalism. So what you get with cooperative federalism, with dual federalism, if we had a cake, there would be two layers. One layer would be the national government, one layer would be the state government. But with cooperative federalism, you can see it's more like a marble cake. What the state does and what the national government does kind of gets intermixed with each other. It still holds its own entity, but they're just much more intertwined than they were under this theory of dual federalism. So how does with this cooperative federalism, how does the federal government reach out and get the states to do certain things? And they do that by grants. They do that by grants. Now, there are a number of types of different grants. One of them is categorical grants. And with a categorical grant, a federal formula to limit states' discretion in the use of the funds, which are subject to strict administrative criteria. So now, categorical grants, just as the name suggests, is you can only do certain things with this money we give you based in this category. So it's very restrictive. And so what was happening, the grants were becoming so restrictive, the states weren't able to use them. And so there was some backlash. And so then the federal government started using block grants. So a block grant is a grant that comes with less stringent federal administrative conditions and provides the states, they're the recipients, with more latitude over how to spend the grant funds. So again, going back here, if you've got the national government providing the funds, the states are administering it, but if they're so restrictive, there was nothing for the states to administer because there were so many conditions, the red tape, that they couldn't go about doing it the way the national government wanted, and they could be fined, have to pay back the money. So it was a nightmare. So they went to block grants. The problem with federal aid is federal aid equals federal control. So if you accept the money, you've got to accept the conditions of aid. So conditions are aid of what a state government must do if it receives the money. For instance, in Salt Lake City Unified School District, they wanted to take some. Well, let me back up. So there was an individual who wanted to have a club. They wanted to have a gay club, and Salt Lake City, Utah in general, is a very conservative state, and the principal said no. Some of the kids that wanted to have this club went to the school board. The school board said no. Their parents got the ACLU involved, and the ACLU sued the Salt Lake City Unified School District because of discrimination, because they wouldn't let the gay kids have a club. The court came back and told Salt Lake City Unified School District, if you don't let them have a club, you're going to lose all of your federal grant money that helps pay for your school. The Salt Lake City Unified School District came back and said, no clubs. No clubs. Then there's just no discrimination. And so you see this conditions of aid equal federal control. In this case, Salt Lake City Unified School District was able to fight back, but it cost them all their clubs. Mandates. Mandates are what a state government must do regardless of compensation or aid. So sometimes the federal government will come and tell a state, you have to do this. That's a mandate. Doesn't matter that we don't give you any money to do it. You got to do it. That's a mandate. Restraints forbids the states from exercising a power. When the federal government comes and says you can't do this, that is known as a state. There's also something known as preemption, and preemption takes place when the central government, the federal government, takes what was once state power and preempts it by federal law. So these things all deal with state and federal relations with respect to federalism. Now, we've already talked about the last thing. I think we've already talked about the full faith and credit clause. Yes, we did. Okay, so duties owed that states owe to each other in this federal system. So we've already talked about this one in a previous slide. Let us go to the extradition clause. So states actually, if a criminal flees from one state to another state, somebody commits a crime and they take off across state borders to try and not be arrested. The Constitution requires the states to which the person fled from return that person to the state from which they fled. This is the extradition clause, requirement by the Constitution. The privileges and immunities clause, and yes, we already talked about that one too. So you've got to give individuals the same privileges and immunities of citizens of the state. All right, I hope this was helpful. Hope things are going well for you. Email me as always if you have a question. And this is the only PowerPoint for this chapter. I didn't break it up into two.